legit. Anything you want.
Ripple lawyers try to move securities lawsuit to federal court in slick move. Lawyers representing payment startup Ripple and its ongoing securities lawsuit are trying to move the case to a federal court in a show of woodwind. Legal commentator ascribed tactical brilliance. November 9. Court records confirm the application to move the case from state to federal level, which would allow Ripple to prove definitively that its RPOK and is not a security under U.S. law, should it win. In the removal filing, litigation partner Peter Morrison said the case meets each of the requirements needed to allow the change to go ahead. Legal industry magazine AW.com notes. The latest development is another step in the complex road to court for Ripple investors, 4 of whom originally brought separate claims against the company over its alleged securities law violations. The claimants all lost money from purchasing XRP at high prices earlier this year, but opted to sue to include all possible parties affected since 2013. The lawsuits have now been consolidated into one process. Commenting on the idea by Ripple's defense team to switch venue to federal level, securities lawyer Jake Travinsky applauded what he said was a lick move. Can't speak to their odds of winning since the case is still so young and I don't know all the facts, but it's fair to say Ripple's lawyers think they have better odds of winning in federal court than in state court, or else they wouldn't be trying so hard to remove the case, he wrote on Twitter November 9. XRP has slowly returned to form in recent months. Meanwhile, last week briefly overtaking Ethereum ETH to become the largest LTCOINY market capitalization. In September, Ripple settled another legal dispute with banking consortium 3.
Ripple Labs sees third XRP cryptocurrency securities fraud lawsuit. An investor in Ripple Labs XRP cryptocurrency filed a lawsuit in California against the platform under California's corporate code. The lawsuit was for securities fraud and it is the third one within a span of 2 weeks. The 2 prior suits were filed in the same county and one of them has been removed to federal court in the Northern District of California. All 3 lawsuits have named Ripple's subsidiary XRP2 LLC and its CEO Bardley Garlinghouse as defendants. Further, the complaints allege that due to the centralized method for management and distribution of XRP and the way the platform conflates the cryptocurrency with its own product offerings, XRP should be classified as a security and accordingly, the platform violated securities laws. One of the lawsuits, which is a class action, features a complaint that provides in-depth explanations as to how the platform allegedly influences XRP to increase prices. This is significant, because the complaint may show that the Howey test for the definition of a security has been met. The test was identified in SEC v. Howey. The complaint also alleges that the platform's actions were performed to drive price appreciation and to maximize profits from XRP sales. It was also determined that XRP's prices increased over 1,000%. Additionally, XRP is managed in a manner that is different from other cryptocurrencies. For instance, while Ether and Bitcoin are mined on a blockchain by individual users to become actualized property, XRP has 100 million units in existence, 61 million of them which are owned by Ripple Labs. Counsel for Ripple Labs has successfully petitioned the court to dismiss the allegations of fraud, arguing that only the U.S. Securities and Exchange Commission can decide whether XRP is a security and the XRP is solely a cryptocurrency. Ripple's chief cryptographer argued that XRP cannot be a security because Treasury's Financial Crimes Enforcement Network stated that CRP is a cryptocurrency and approved its sale. Even with the above circumstances, there is still a question as to whether a previous settlement impacts present case. According to a partner at Loeb & Loeb, a contrary finding by a court of the SEC would arguably contradict the FinCEN determination, and no one could also surmise the SEC would not be quick to contradict FinCEN. But that is all speculation. If the court or regulators do determine that XRP a cryptocurrency and is subject to federal securities law, the consequences could set precedent in California. XRP would need to stop trading and individual owners of the currency will be granted the right of recession, so Ripple would have to refund initial purchases.